Heard.
And my lord, if I may add a few, my lord, Mr. S.K. Mehdi will be representing the respondent number 13, who is to be impleaded, and his associate is online, if I'm not mistaken.
No, we are allowing your petition.
My lord.
You make necessary correction in the cause title of by impleading
My lord.
the person as respondent number 13. Heard Mr. Lalro Kunga Pautu, Learned Counsel for the applicant. This application under Order 1 Rule 10 read with section 151 of the CPC has been filed in connection with contempt case number 15/2023, praying for impleading new incumbent to the post of Deputy Chief Engineer, NF Railway Construction, as respondent number 13. Learned Counsel for the petitioner has submitted that the earlier incumbent has been transferred,
Yes.
and earlier incumbent to the aforesaid post has been transferred, and Shri Arvind Kumar Meena has joined as Deputy Chief Engineer, NF Railway Construction, and as such there is requirement of impleading him as respondent number 13 in the connected contempt case. The prayer is allowed. Let the name of Shri Arvind Kumar Meena be added as respondent number 13 in the connected contempt case. You will file the amended cause title.
Within a week, my lord.
Okay. The applicant shall file the amended cause title in the connected contempt case within a week from the date of this order. This interlocutory application is accordingly disposed of.
I'm obliged.
Item 4.
Yes.
May it please Your Worship? Your Worship, the grievance of the petitioners is that their lands have been encroached upon and utilized by the railways authorities, respondents number 1 and 5, for construction of the railway station and peripheral railway line. In spite of this, they have not been paid any compensation and they were not included in the acquisition proceedings. The railways had acquired the land falling within the area of the land belonging to the petitioners by way of an award passed by the competent authority, that is Draft Award 3 of 2019. Acquisition proceedings were made under the Railways Act of 1989. And Your Worship, all the adjoining areas of the lands near the petitioners' lands have been acquired. The petitioners' lands have not been acquired, but their lands have been utilized for construction of the railway line as well as the railway station. So the petitioners had approached the Deputy Commissioner, Aizawl District, who was the competent authority, and spot verification was conducted on 2 occasions. And on both occasions, it was verified that the land belonging to the petitioners had been encroached upon. But in the end, the competent authority had directed the petitioners to approach the court for redressal of their grievance. So in the end, Your Worship, we had to file this writ petition. And in the affidavit filed by the state,
Now, why they are not acquiring the land?
they were missed out.
But your land has been utilized.
Yes.
No, what is the stand of the railways?
My lord,
Railways stand
There is
that-
disputed question of facts has been involved in this case. Because we already acquired the land as per award, then payment already be civil court only.
Your Lordship, if I may answer that. The affidavit filed by the state has clarified everything. The genuineness of the passes belonging to the petitioners and the fact that they were not included in the award, the fact that their land has been utilized. If I may take Your Lordship to the affidavit filed by the state, it was
Who is appearing for the state?
Wait.
Your Worship, the matter is handled by my learned friend, Leonard Louis, which is on legacy, Your Worship.
If it requ-
Para 5 of the affidavit filed by the state.
state is 2, 3 and 4.
2, 3 and 4. Para 5, Your Worship. If I may read. At page 4.
Yes.
It is also humbly submitted that at present stage, it has been observed that the lands of the petitioners have been completely damaged due to excavation works undertaken for the railway station and the peripheral railway line, thereby rendering on-site spot verification untenable and incapable of yielding an accurate assessment owing to the altered physical condition of the land. However, as per alignment details and right-of-way mapping prepared by Warner Geo Solutions, who were engaged for preparation of railway map and corroborated by the survey's records, it has been verified that the locations of the 3 petitioners' house passes are all adjacent to and connected with the house pass of H. Chinzapawa and all fall within the railway right-of-way. Further, despite the above-mentioned lands falling within the same railway right-of-way, it is noted that compensation was awarded only to H. Chinzapawa under Railway Award 3 of 2019, and no such compensation has been extended to the petitioners concerned. So, Your Worship, this is the stand of the state. Our lands have been excluded from the award, although it has been encroached upon and has been utilized for the construction of the railway station as well as the peripheral lines. So when this is the stand of the government, it is clear that we have been mistakenly left out.
What is the stand of the railways?
The stand of the railways is that demarcation process was
My
required.
lord, it seems that the petitioner land is bogus claim on the same land. However, we already acquired the land and payment already been made on it. There is no more liability of
No,
Union
but
of
state
India.
is saying that petitioner's land has been used. It
My
comes
lord-
within the right of way.
Because we are working on the right of way, then we already handed, the site had already been handed over to railway by state government as per law. Then if there is some dispute, they have to go to civil court, my lord.
No, what is your contention?
The
Regarding
petitioners
the
cannot be left
FE.
high and dry just because the land was handed over to them by the authorities concerned.
The entire acquisition, my lord, if I may, in my affidavit that was filed on 22/9/2025, at para 15.
Just a minute. Some spot verification was done
On
to
2
verify
occasions.
Draft award was submitted by the
state government.
state
Yes.
authority on
where the
4/7.
representative, just a minute, where the representative of railways were also there.
Yes, Your Honor. If I may take a lordship to page 42.
now that land is in your possession. It has, the work has been completed,
Yeah, land is in the railway's position.
your land also.
Yes. We submitted complaint to the complaint authority, verification was conducted, and the verification also had verified that our lands have been.
Where is that verification
Your Worship will allow me to tell page 44
of your petition?
of my writ petition. Page 44.
Yes.
Your Worship will see the petitioners are at paragraph number 2. This is the report submitted by the SDC, Aizawl District, Aizawl, to the Deputy Commissioner dated 29 September 2023. In pursuance of order number so-and-so dated 24/7/2023,
Whose order is this?
this order is passed by the competent authority. This is at page 42, Your Worship. This order dated 24th July 2023 is at page 42. This is the detailment order. Page 42, annexure 8. May I read, Your Worship? Annexure 8, page 42. Your Worship. This is the detailment order.
Okay. The representative of railways were also there.
Yes.
Okay.
And this is the report of the verification process, which was conducted on 31st July 2023. Your Worship. The petitioners appear at serial number 2, the Vungi. Changes and action taken on land not previously acquired by NF Railways was found. Picture enclosed. Landowner stated the above mentioned lands had different land parcels, but
What is this Dim Nyang?
Your Worship, she's the
Name of the,
landowner. She's petitioner number 3.
as regards other
Sorry,
petitioners?
she's petitioner number 2, D. Vungi.
Okay, petitioner number 2.
Yes. And if your Lordship will see, if I take your Lordship back to page 42,
Yes.
list, your Lordship will see enclosure, list of complainants / landowners. Has your Lordship gone?
Yes.
And the next page, page 43,
Yes.
serial number 9,
Yes.
3 house parcels, 335 of 2015, 336 of 2015, 338 of 2015. Damaged crops and land beyond acquired area. An area of 2055.90 square feet out of 4607 was acquired under house pass number 337 of 2015. Your Worship, 337 of 2015 belongs to the husband of the petitioner number 2,
And these houses are adjacent to that,
adjacent to each other.
and your land and house were not acquired.
Yes. So this was the complaint, and the verification report at page 44 clearly stated, changes and action taken on land not previously acquired by NF Railways was found. Picture enclosed. Landowners stated the above mentioned lands had different land parcels but within the same family. Reassessment by Bonnail Solutions and surveyor may be necessary for mutation of the acquired area from the non-acquired area for determining the extent of encroachment. Then again, Your Worship, at annexure 10, page 47.
What is this Borneo Solution and Surveyor?
Bonnail Solutions, Your Worship, is the they are the surveyors. The state government in their affidavit have annexed the agreement executed between the,
On the basis of their survey report, land was
Yes.
acquired.
if I take your lordship to the affidavit filed by the state,
Yes.
page 18. Page 18 is the agreement which was executed between the Deputy Commissioner Aizawl District and this Buannell Geo Solution and Services. They were engaged by the Deputy Commissioner to perform the work of survey and mapping of all lands which fall within ROW.
But as per their survey, your land does not fall.
Yes, as per their survey, our land falls within the ROW. In fact, your lordship will see the affidavit filed by the state. Para 5, again. As your lordship got the state affidavit, para 5,
Yes.
page 4, the last part. However, as your lordship got,
Yes.
however, as per alignment details and right-of-way, mapping prepared by Buannell Geo Solutions, who were engaged for preparation of railway map and corroborated by service records, it has been verified that the location of the three petitioners' house passes are all adjacent to and connected with the house pass of H. Chinzapawa and all fall within the railway right-of-way. Further, despite the above mentioned lands falling within the same right-of-way, it is noted that compensation was awarded only to H. Chinzapawa under Railway Award number 3 of 2019, and no such compensation has been extended to the petitioners. So, as per alignment details, and that has also been annexed by the state, Your Worship.
Now, why initially they were excluded if the survey reported? This is a subsequent report of the surveyor?
Yes,
Or they,
after we submitted complaints.
in their earlier report?
Yes, so we submitted complaints, and then on the basis of our complaints, spot verification was conducted in the presence of all parties. That is at annexure 8 and 9. So there also the finding of the verification report was that our lands have been encroached upon. Then if I may take your lordship to page 47. This is again another detailment order, second detailment order. Page 47, annexure 10 of the writ petition. May I read you?
Yes.
In pursuance of verification report submitted by sub-divisional officer of the office, the following officials are hereby detailed to conduct assessment, survey and measurement of encroached area in connection with construction of railway line within Aizawl district on 7/3/2024. Again, assessment, survey and measurement was conducted. And at page 48, this is the report submitted by the concerned officer. And page 49 is the report, Your Worship, regarding the petitioner's lands. If I may read from page 49, the remark of the concerned officer. During verification, a copy of land plan, copy attached and listed as Annexure 2, was produced by the representatives from NF Railways. In light of the document produced, it appears that the site described by the landowner as the land was demarcated under ROW and acquired by NF Railways. The landowner, however, stated that no compensation was paid to them. Copy of the land pass, it was stated, was already submitted to the DC office. Suggestion: the office of Deputy Commissioner Aizawl may seek information on ownership of land from the area claimed from Land Revenue and Settlement Department, Aizawl. So this was also done, Your Worship. If I take your Lordship to the affidavit filed by the state,
Yes.
On the basis of this suggestion, at page 15 of the affidavit filed by the state, Your Worship. Page 15,
Yes.
this is the letter dated 13th of May 2024, written by the Deputy Commissioner to the Revenue Department Director. Subject: request to confirm ownership of land parcels. Reference: joint verification report dated 13/3/2024. With reference to the subject and letter cited above, I have honor to request the following information with respect to the owner of house pass number 335 of 2005, 336 of 2015, and 338 of 2015, which is currently a contested site demarcated and acquired by NF Railways. Enclosures are there, and this is the reply of the page 16. The page 16, with reference to the subject, and let us have the honor to forward herewith information.
How many petitioners are there? Three.
Three, Your Lordship.
These are the three petitioners?
Yes, page 17. If Your Lordship will see page 17.
Yes.
This is from the settlement officer to the director. With reference to the subject mentioned above, as requested by Deputy Commissioner, the owner of house pass number 335 of 2015, 336 of 2015, and 338 of 2015, located at Sairang, as records in guard file and general register are as follows. So even the genuineness and ownership of the passes has been confirmed by the Revenue Department in favor of the petitioners. So the affidavit filed by the state clearly shows that we are the genuine owners of the three passes. Our passes have, the lands belonging to the petitioners have been encroached upon and utilized by the railway authorities for construction of railway station and railway line, and that we have not been paid any compensation. The stand of the railways is that they are working within the right of way which was included in the award. But that, Your Worship, it is clear that we have been mistakenly left out. So how can the petitioners be left high and dry due to the mistake committed by the state? Verifications were conducted. It has been verified. Even the state government has verified that our lands belonging to the petitioners fall within the right of way, but they have not been compensated.
Okay, now you want your land to be acquired
Yes,
and award to be made.
yes. Well, I'm relying on two Supreme Court judgments. 2020 Volume 2 SCC 569.
Yes. Para?
I'll read from para 12.3, page 573. Page 573, para 12.3.
Yes.
To forcibly dispossess a person of his private property without following due process of law would be violative of a human right, as also the constitutional right under Article 300A of the Constitution. Reliance is placed on the judgment in Hindustan Petroleum Corporation versus Darius Shapur, Chennai, wherein this court held that, having regard to the provisions contained in Article 300A of the Constitution, the state, in exercise of its power of eminent domain, may interfere with the right of property of a person by acquiring the same, but the same must be for a public purpose and reasonable compensation thereof must be paid. So, Your Worship, it is been held that this possession of a person of his private property without following due process of law is violative of a human right as well as the Article 300A of the Constitution. If I may take Your Worship to the next page, para 12.9. In a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without sanction of law. Reliance is placed on the judgment of this court in Tukaram Kata Joshi versus MIDC, wherein it was held that the state must comply with the procedure for acquisition, requisition, or any other permissible statutory mode. The state, being a welfare state governed by the rule of law, cannot arrogate to itself a status beyond what is provided by the Constitution. 12.10, para 12.10. This court in state of Haryana versus Mukesh Kumar held that the right to property is now considered to be not only a constitutional or statutory right, but also a human right. Human rights have been considered in the realm of individual rights, such as right to shelter, livelihood, health, employment, etc. Human rights have gained a multifaceted dimension. Even in this case, Your Worship, the land of the petitioners herein in the Supreme Court case was utilized for construction of a road, and no compensation was given to them. Subsequently, the petitioner had approached the courts, and in the end, the Supreme Court had directed that her land also should be acquired in accordance with the land of the adjoining landowners whose lands were acquired under the provisions of the LA Act 1894. Para 15, if I may take para 15.
Here the acquisition was made under which law?
LA Act.
1894. Yes. Para 15.
Para 15. In view of the aforesaid facts and circumstances of the present case, respondent state is directed to pay compensation on the same terms as awarded by the reference court by order dated 7/7/2015 in Anak Singh's case, along with all statutory benefits including solatium, interest, etc. within a period of 8 weeks, treating it as a case of deemed acquisition.
Deemed acquisition. But here you are praying for acquisition and then entire process has to be undergone.
Yes, Your Honor, because the land belonging to the adjoining landowners has been acquired under the Railways Act, 1989.
Railways Act.
Yes. The award was passed in 2019. So, the land of the petitioners also may be acquired accordingly as per the Railways Act. Notification was already issued under 20A, 20E.
Railways Act.
Your Honor,
Okay. What else is your submission?
Your Honor, again, there's another judgment of the Apex Court, 2022 7 SCC 508.
Seven SCC.
2022 7 SCC 508.
Para.
Para 22. In this case, the earlier case was referred to by the Honorable Supreme Court. Para 23. The judgment passed by the Supreme Court in the earlier case was also referred to. Para 23. This court in Vidya Devi, facing an almost identical set of facts.
This you have read already.
Yes. Then I'll take your lordship to para 25. 5.
Yes.
Concluding that the forcible dispossession of a person of their private property without following due process of law was violative of both their human right and constitutional right under Article 300A. This court allowed the appeal. We find the approach taken by this court in Vidya Devi is squarely applicable to the nearly identical facts before us in the present case. So, Your Worship, in our case also there is dispossession of the lands belonging to the petitioners, which is violative of their human right as well as violative of Article 300A.
Okay.
So, my humble praise, Your Worship, is that the lands of the petitioners may be acquired in terms of the Railways Act, which also, according to the railway authorities, they claim that it has already been acquired. We fall within the right of way. But the verification report and the affidavit filed by the state clearly proves that although our lands fall within the right of way, but our lands have not been included in the award and we have not been paid any compensation.
Yes.
My lord, if I may, I filed affidavit on 22/9/2025. The land acquisition has been done properly through the state respondent, my lord. Annexure 1, page 8 is notification, my lord. And Annexure 2, page 11, the name of the present petitioner is not included. Acquisition has been done properly as per law, as per acquisition. Then the same has been done through the state agency, my lord. Everything has been done properly, legally. Then at para 8 of my affidavit, my lord, the answering respondent states that railway is always working within its right of way, ROW. Draft award was submitted by the state authority on 4/7/2019, based on which railway makes payment on 30/3/2020. After making payment, the land is handed over to railway on 5/2/2021. So there is no question of encroachment of the petitioner's land. That is one of my stand, my lord. Then at para 14, the answering respondent stated that the railway is working within the right of way, ROW, and makes payment to those landowner whose assessment was given by the DCI zone office. So question of land encroachment does not arise. As the railway land plan also, there is no demarcation of landowners' land. So question of left out does not arise. Then 15, the answering respondent states that the entire land acquisition was done as per Land Acquisition Act, and railway is also working within each ROW. A draft award was submitted by the state authority on 4/7/2019. Railway made payment on 30/3/2020. And after making payment, the land was handed over to railway on 5/2/2020. Then, my lord, we already acquired the land. Then payment also paid to the state government, my lord. That we already been acquired the land. However, if the petitioner claimed that their land has been damaged by the railway construction, they have to approach the civil court for taking evidence to show that whether they have a genuine land or not. They may have a land, however, it may be included in the right of way. That means they have no right to have a land pass within our right of way, my lord. They have to cancel it. Then that is why there is a disputed question of facts has been involved. Then the matter may be dismissed and liberty to file approach in the civil court, my lord. That is my stand. Obliged.
Let the state come, then give your reply.
Your Worship, just a
Who
short.
is appearing for
Your
this?
Worship, my learned friend is on her way. She's coming down from.
We'll take it up. Let her. Who? What is her name?
Handle Louis.
Okay, let her come. We'll take it up.
Yes.
In the meanwhile, we take up other matters.
Yes.
Ah, yes.
Item 5.
May I plead your lordship?
Yes.
Lordship, this is in regard to item number 3. Due to some technical issues, I was unable to connect your lordship. Lordship, I am appearing for respondent number 12.
Item number
we need
3,
some-
we have already passed order. What orders? Huh? Yes. Yes, what is your submission?
Lordship, we need some time to file Wakalatnama as respondent number 12 has already been transferred. New person has joined in place of him.
We have allowed the impleadment petition.
Yes, Lordship.
You may file Wakalatnama on the next date fix.
Lordship, one more request. Lordship, can it be fixed on 23rd Feb 2026?
No, the council
February.
is not present now. Mr. Pautu is there. Can it be, date may be altered? Okay, when do you want it?
23rd 02 2026.
Item number 3, show her presence. What is your name?
Lordship, I am M. Das, appearing on behalf of SK Medhi.
Also heard Ms. M. Das appearing on behalf of Ms. N.C. Mr. S. K. Medhi, learned CGSC. Baki Eke Thakibu, list this matter on which date you are seeking? 23rd.
23rd.
23rd February. Instead of 12, it is 23rd February.
Masih kenal din tayo.
Much obliged.
Shall we continue with the previous matter or continue with this item 5?
We'll continue with the, we'll complete the orders.
Mr. Mahotas, please. Should we continue with Mr. Mahotas, please?
Yeah, end na work.
After we finish the orders, because here it will be disposed of today itself.
This is lecture.
Tutusin na nila ka. Tutusin na nila ka.
Yes, item number 5.
Your Lordship, if I may be granted time to file my objection in the matter, Your Lordship.
Submit a prayer for union, my lord. For respondent number 1 to 3.
Okay, what is your name?
Stephen Lalwat,
Heard Mr. C. Lalram Zuawa. No, Stephen. Sorry, heard Mr. Stephen Lalboat Saiha, learned counsel for the petitioner. Also heard Ms. Mariel Kangte, Ms. Zairem Sangpui appearing for respondent number 1 to 3, as well as Ms. Mary L. Kangte, learned government advocate appearing for respondent number 4 to 7. Both the learned counsel for the respondent have prayed for some time for filing written objection in this case. The prayer is allowed. Let this matter be listed after 3 weeks.
Item 6.
below.
Yes. Heard Mr. Victor L. Ralte, learned counsel for the appellant. This appeal under section 17 within bracket 2 within bracket small b of Mizoram Civil Codes Act, read with order 41 rule 1 and section 151 of the Code of Civil Procedure 1908, has been filed by the appellant Srimati Melody Lalrin Wami, impugning the order judgment and order dated 27/5/2025 passed by the Court of Learned Civil Judge Senior Division Number 1, Aizawl, in civil suit number 21/2024. You were the plaintiff. Your
Yes, my lord.
suit was dismissed.
Yes, my lord.
Also heard Miss Mary L. Kyante appearing for respondent number 2, 3 and 4. Stop. Issue notice to
My
this.
lord, my lord, notice was already issued. Parties were duly represented by their respective counsels. This, besides this RFA, my lord, there is a connected IA.
Okay, notice. Interim order is there.
Yes, my lord.
What interim order?
There's a parallel trial. There's a probate case and civil suit. And after filing this appeal, my lord, the probate case was stayed by this court.
But probate case is not the subject matter of this suit.
But my lord, that probate case was kept in abeyance while the civil suit was heard in the preliminary hearing.
Now civil suit has been dismissed.
Civil suit has been dismissed. One of the reasons of dismissal of this suit was, my lord, there's under section 10 of CPC, res sub judice.
No, you have to approach the court in connection with the probate case.
My
File.
lord, there was a parallel trial on the same subject matter. And
What was this? What was the relief sought for in this civil suit?
to
Right title and
adjudicate the true owner of the suit property.
in probate case it is only grant of probate.
Yes, my
Whether-
lord. But the allegation was that the testator of the will does not have the authority to grant will. The probate case was first kept in abeyance, and after that the civil suit was heard. But the learned trial court had wrongly held that it was res sub judice, while the probate case was already kept in abeyance.
Okay, whether records have arrived.
No, my lord.
An appearance of respondent number 1.
Respondent number 1 already represented by the respective counsel, but no one appeared.
Our has been filed on behalf of the court, but no representation to the election.
Cut off. Cut. Yes, what is the submission?
My lord, at this stage, my lord, the I can be disposed of.
Huh?
The interim may be made obsolete pending final disposal of the appeal.
Whether trial court records have arrived.
If I'm not mistaken, the court records have not been called.
Requisition. Trial court records would be necessary.
It's in the preliminary stage, my lord, nothing is there.
Okay.
But for the safe side, to avoid complications at the time of final hearing, it may be called for.
And whether appeal was admitted? Yes, it is admitted.
Already admitted, my lord.
Yes.
So, my lord,
Heard,
the appeal having
heard
already
Mr.
been admitted,
Victor
my
L.
lord,
Ralte.
the IA may be disposed of as allowed.
In main RFA, heard Mr. Victor L. Ralte, learned counsel for the appellant. Also heard Miss Mary L. Cante, learned government counsel appearing for respondent number 2 to 4. Though it appears from record that the respondent number 1 has been represented by counsels, names of whose names are also reflected in the cause list. However, today no one is present before the court to represent respondent number 1. It also appears that this appeal has already been admitted. The trial court records would be necessary for consideration of the instant appeal. Hence, call for the trial court records. The registry to take steps for requisitioning the trial court records. Let this matter be listed after 3 weeks after receipt of the trial court records. In IA, let the respondent number 1 appear. Let them be present.
Yes, my lord. And by the way, my lord, I was confused. I take back my submission that the probate case is not stayed by this court. Only the operation of the impugned judgment has been stayed by this court. And in the probate case, on our application, separate application in that case, in the London concerned court. Now the London trial court had stayed the proceeding of the probate case on its own.
Okay.
I take back my submission. I'm sorry.
But how a operation of a dismissed order can be stayed?
This impugned. The
Impugned
operation
by-
of the impugned order is alone has been stayed by this court.
No, the impugned judgment is is in the manner of dismissing your suit. Your suit was dismissed.
As a result of dismissal of this suit, my lord, the probate case which was earlier kept in abeyance revived.
Now, whether dismissed suit can be, what would be the consequence of such stay?
The probate case was kept in abeyance earlier, prior to dismissal of this suit.
Okay, what for you have filed? There.
Besides staying the impugned order, my lord, I have also paid for staying the proceeding of the probate proceeding.
Will issue notice.
Notice was already issued, my lord.
Let them appear.
Yes, my lord. And until the next 4 days, my lord, the interim order, whatever passed earlier, may continue.
No, you make me understand how a suit which was dismissed can be stayed.
I'm praying for this staying of the operation of the dismissal of the
Where is
suit
the
because-
provision? Where is the provision? Under Order 41, Rule 5, only execution of a decree may be stayed. This application is under Order 41, Rule 5.
As well as, my lord, I'm also invoking Section 151 of the CPC in hand power of this honorable court, my lord.
This is, I think, not maintainable. By Order 41, Rule 5, what can be stayed? Read Order 41, Rule 5.
I understand your point, my lord.
Unless suit is decreed, there cannot be anything like stay of a suit which has already been dismissed. There is nothing to be stayed. That is my understanding. Make me understand otherwise if I am wrong.
As a result of dismissal of the suit, as I have submitted earlier, my lord, the probate case, which is also dealing with the same subject matter, which was kept in abeyance after filing of the suit, is now revived. In fact, my lord, in my RFA, my lord, in the memo of appeal, I have enclosed one order at page number 115.
Whether your copy of your plaint is there in this,
Yes, my lord.
where is the page number?
Plaint,
Copy of plaint which you have filed in,
page number 41 of in the memo of appeal.
where is the prayer portion?
page number 56, running page number 56.
Where is the prayer that the probate case may be stayed? No such prayer was there.
My Lord, in this, kindly see page number 115, running page number 115.
Yes.
This is the order passed in probate case.
No, probate case is not the subject matter of this appeal.
That is correct, my Lord. What I mean to say is that, Your Lordship may kindly see
Okay, we'll take up the,
Your Lordship may kindly turn to page 120, para 25. Page number 120, para 25. This is continuation of the same order, passed in probate case.
so probate, the court has itself, the trial court has stayed the probate case.
At the moment, after filing of this RFA. Because the probate court itself in this order, my Lord, if Your Lordship may kindly see para 25, 26, 27.
Now what is the relief which you are seeking in the IA?
In the IA, my Lord, I have two prayers, my Lord. One is to stay the operation of the impugn order and also to stay the proceeding of this probate case.
Okay, we'll take it up. Let the respondent number 1 appears.
Yes, my Lord. In the meanwhile, the LCR may be called for.
That has already been called for in the.
Yes, my Lord.
In IA Likhito, this interlocutory application has been filed. Now heard Mr. Victor L. Ralte, learned counsel for the applicant. Also heard Ms. Mary L. Cante, learned government counsel appearing for respondent number 2 to 4. No one is present for respondent number 1. Stop. This application under Order 41 Rule 5 read with Section 151 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with RFA number 37/2025 praying for stay of operation of the impugned judgment and order dated 27/5/2025 passed by the Court of Learned Civil Judge Senior Division number 1 Aizawl in civil suit number 21/2024. A prayer is also made for stay of proceeding of probate case number 2/2019 pending before the Court of Learned Civil Judge Senior Division number 4 Aizawl.
6.
Number 6 Aizawl. Learned counsel for the petitioner has submitted that the said probate case is connected to the civil suit number 21/2024 and on an earlier occasion, the trial court had kept the proceeding of probate case number 2/2019 in abeyance till the pendency of civil suit number 21/2024, however, since the said civil suit has already been dismissed, the requirement of instant interim relief of stay of the said probate suit has arisen. Stop. Since the respondent is not represented by any
Respondent number 1.
the respondent number 1 is not represented before the court today, this interlocutory application shall be decided in presence of respondent number 1. Let this matter be listed after you need a fixed date.
It may come up together with the main appeal.
Listed along with
The
connected RFA number 37/2025.
Deeply obliged.
Item 7.
Yes.
My Lord, this is a regular first appeal against the impugned judgment and order dated 18/6/2025, passed by the civil judge Azol in civil suit number 44 of 2021. My Lord, this appeal is already admitted, so my Lord, trial court record may be called.
What about notice to the respondents?
This was already issued.
Power on behalf of the sole respondent has been filed, but no representation to be.
Okay. Heard, Mr. What is your
Alan
name?
Chakpuya, appearing on behalf of Mr. Bilar Ramayana.
Write his name. Learned counsel for the appellant. On perusal of the records, it appears that the sole respondent has filed, that wakalatnama has been filed on behalf of the sole respondent. However, no one has appeared for the respondent today. It also appears that this appeal has already been admitted. However, the trial court's record have not yet been requisitioned. Hence, let the records of the trial court be called for registry to take steps for requisitioning the records of the trial court. List this matter after receipt of the trial court record after 2 weeks.
Obliged, my Lord.
Item 8.
Item 8. Mr. C. Zoram Chana was present. What is to be done? We'll show his presence and or we'll take it up after some time.
Item 9.
Please, Your Lordship, we still have not traced the addressed or the location of the sole respondent till date. If I may be given another 1 week time, if things could not be sorted out, then maybe we will have to consider taking alternate steps for serving a notice, like publication in newspapers, etc.
No, whether notice may be served through the officer in charge of.
We did, Your Lordship. We cannot find the exact location. He was not there in the previous address that we used to know, but then there has been a consistent search as to his whereabout. But till date, we do not know his whereabout.
No, but some report has to come from how you have taken steps.
By Dusty, we have sent it to the Home Department, and the Home Department have sent it to the SP Legal, and then from there they have taken steps to the concerned police station.
Jurisdictional police station.
Yes.
Whether any report has been received.
I have received, but I haven't filed by way of affidavit. I can file it by way of affidavit.
And report is that they have not.
They have not found.
No, we'll reflect your submissions. Heard Miss Mary L. Kante, Learned, Additional Public Prosecutor, appearing for the appellant / applicant. There is a delay, or this is leave?
Yes, Your Lordship.
Delay is there? No.
No, Your Lordship.
Okay. Learned,
This is special leave to appeal.
Learned, Additional Public Prosecutor submits that the notice issued to the respondent, sole respondent, through the Home Department as well as jurisdictional police station could not be served on the respondent, as the exact address of the respondent could not be located. The address is also not very specific. Klang Nuam West is a.
Yes.
She therefore seeks a week's time to again make an attempt for locating the proper address of the respondent and serving the notice on the said respondent. The prayer is allowed. Let this matter be listed after a week.
Your Lordship.
Item 10.
Your Lordship, we have taken steps. We have taken steps to serve notice to the respondent number 1 and 2, but then till date they are not represented.
What is this?
This is an application for condonation of delay
Condonation.
of 262 days.
As per office note, fresh steps has to be taken on respondent 1 and 2, but till date, steps have to be taken, fresh steps have to be taken.
Oh yes, office note says that you have not taken steps.
Oh. A fresh steps, I think. Because we have taken steps on 7/5/2025, and if maybe I'm mistaken after that, maybe there's a new direction after that.
Okay, you take fresh steps.
Yes, Your Lordship.
Heard Miss Mary L. Kante, Learned Government Advocate, appearing for the applicants. Who prays for allowing the applicants to take fresh steps for issuance of notice upon the respondents. The prayer is allowed. The applicants/appellants shall take fresh steps for issuance of notice upon the respondents by speed post as well as
Your Lordship, with Your Lordship permission, by way of Dusty, it would be more convenient for us.
it will be alternative mode.
Oh.
By speed post,
Your Lordship, we have already taken steps by way of AD card on 7/5/2025.
that is
So
when
that was not effective.
you take fresh steps by speed post. We will get the track consignment report
Okay, yes, all right.
by speed post within a weeks from the date of this order, returnable only. Give a returnable date after in the month of March,
The 5th of March.
returnable on 5th of March. The applicant is also allowed to additionally take steps for issuance of notice upon the respondents by way of Dasti mode stop. In the event the applicants are able to serve the notice by Dasti mode, the applicant shall submit an affidavit of compliance thereto before this court on the next date fixed, list accordingly.
Deeply grateful, Your Lordship.
Item 11.
My Lord, I'm for respondent number 1. And in the last court's order, we are to file this written objection. However, my Lord, we haven't filed it yet because we haven't received appeal petition copy from the appellant's side. As it has to be read together with the
There is nothing which has been mentioned in the memo of appeal.
You
regarding
furnish a copy of memo of appeal to her. You furnish a copy of memo of appeal. How many respondents are there? Only one.
as well as the state respondents, my lord.
You are appearing for respondent number 1.
number 1.
And who is
The rest
appearing
are
for
the
this?
state respondents, your lordship.
Heard Mr. Jonathan Lalrin Tuanga, learned counsel for the applicant. Also heard Miss Ruth Lalruat Feli, appearing for respondent number
1.
1, and Miss I forgot your name.
Lalnan Louis, Your Lordship.
Yes. You have to assist. Heard Miss Lalnun Louis, learned government advocate, appearing for the state respondent. Learned counsel for respondent number 1 has submitted that as the respondent number 1 has not yet been furnished with the memo, a copy of memo of appeal, they are unable to file written objection in this interlocutory application, and therefore prays for directing the applicant to file a copy of memo of appeal. The learned counsel for the applicant undertakes to furnish the same during the course of the day within
this week, your lordship.
within 2 days from the date of this order. Let this matter be listed again after a week.
Obliged.
Item 12.
May it please your Lordship. Lordship, this IA is filed under Section 151 of the CPC for disbursement of rupees 37,56,718 rupees from the registry of this court by way of check bearing number 344-003, which was deposited by the appellant on 23rd January of this year, 2026.
Yes. Your insurance company,
My lord, yes.
you have any objection?
I think the said money is
How
now
much money was deposited? Entire money or 50%?
50% of the awarded money. The awarded money is 75,13,430.
If you don't
For-
have any objection, let them take the... Okay. Heard Mr. Michael
Lalshiat
Pach.
Ringapatswao.
What is your name?
Michael Lalshiat Ringapatswao.
Michael L. Pachua,
Yes, Lordship.
learned counsel for the applicant. Also heard Mr. Lalrem Tluanga, learned counsel for the respondent insurance company. This interlocutory application under section 151 of the Code of Civil Procedure, 1908 has been filed by the applicants. All are claimants.
Yes, Lordship.
And filed by the applicant's claimants in connection with the connected MAC appeal number 16/2025, praying for directing the registry to disburse the 50% of the awarded amount which was deposited by the insurance company in pursuant to the directions of this court before the registry of this court on 23/1/2026. Stop. Learned counsel for the applicant has submitted that as a condition for staying of the execution of the impugned judgment and award, the insurance company was directed to deposit the 50% of the awarded amount which they have deposited. He submits that as the present petitioners, present applicants were the claimants, they may be allowed to receive the deposited, receive the amount, receive the 50% of the awarded amount deposited by the respondent insurance company. Stop. Learned counsel for the respondent insurance company does not have any objection to the prayer made by the applicants. Hence, same is allowed. The registry of this court is directed to disburse the 50% of the awarded amount deposited by the insurance company within bracket rupees 37,56,718 only to the applicant's claimant after proper verification. This interlocutory application is accordingly disposed of.
Much obliged.
My lord, in this appeal, trial court record may be called for.
Haven't yet been called for.
My lord, trial court record of this MSCT MAC case.
Write the name of the counsel, Mr. Lalrem Tluanga, learned counsel for the appellant, and Michael L. Pachua, learned counsel for the respondent claimant. It appears, oh no, it is not yet, the appeal is admitted or not?
Admitted. Not yet admitted.
Okay.
The
This
appeal may be
appeal,
admitted.
this appeal under section 173 of the MV Act has been preferred by the appellant insurance company, impugning the judgment and award dated 22/4/2025, passed in MAC case number 20/2022 by the Motor Accident Claims Tribunal Aizawl, whereby the insurance company / appellant was directed to pay an amount of rupees 75,13,435 with an interest at the rate of 7% per annum to the claimant respondents. Stop. Mr. Pachua, how to pronounce?
Pachuao,
Pachuao, you are appearing for all the respondents?
all the respondents, Lordship.
1, 2, 3, 4, 5.
1 to 5, yes.
Since Mr. Michael L. Pachau has appeared for all the respondents, no formal notice. You have received the memo of appeal.
Yes, Lordship. It is with me.
No formal notice need to be issued to the said respondent. However, let the records of MAC case number 20/2022 be called for from the Motor Accident Claims Tribunal Aizawl, the registry to take steps for requisitioning the aforesaid record. List this matter after 3 weeks after receipt of the records from the concerned Motor Accident Claims Tribunal.
That's okay.
Much obliged.
Item 8.
We failed to get hold of Mr. Singh also. It's his case.
He was there a bit earlier, Mr.
Not present in court, Your Lordship.
Okay, none appears for the applicant on call. On perusal of the office note dated 5/2/2026, it appears that the notice issued to the respondent have not yet returned. Stop. Await for this tracking group. Not yet returned. However, the postal track consignment report of the notice issued to the respondent is placed by the registry, and on perusal of the same it appears that the notice was delivered to the addressee. Stop. Hence, the notice issued to the sole respondent is held to be duly served. Let this matter be listed after a week on a date to be fixed by registry.
Item 4 for admission.
May it please your lordship. At the onset, your lordship, I admit that I was on legs in the other courtroom.
No,
Hence,
no issue.
I was not able to appear before the court when the matter was called. Your lordship, as per the submission of the state in the affidavit, I may kindly take you to page number 4, your lordship, and number 4.
Your affidavit.
Yes, your lordship, the state's affidavit.
Whether the petitioner's land is affected by the
It is affected, yes, your lordship. That has been admitted by the state respondents in parent number 5, that is page number 4 of the affidavit in opposition filed by the state respondents. If I may be allowed to read, your lordship. Parent number 5, page number 4. It is also humbly submitted that at the present
No,
stage.
yes, Mr. Malhotra has already read it. So what is your stand?
Your lordship, it is only limited to the pleading submitted in the affidavit, that it is in fact falls within the right of way. That is our only submission, your lordship.
Okay. Any
Lordship, just one.
anything else you want to submit?
No, your lordship, beyond the pleadings, I do not have anything to submit.
There's a typing mistake committed by my learned friend at page 4, serial number 3, as your lordship call it, Rosiami, page 4, in the table.
Yes.
Serial number 3,
Rosiami.
daughter of, your house pass number is mistakenly typed as 337. It is 338.
337 is the acquired house.
Yes, this is 338. If your lordship will see page 17.
Yes, what is your submission on the mistake?
Page 17, kind of. Your lordship, page 17. If your lordship will kindly see page 17. In page 17.
That the report of the
regarding confirmation
revenue office.
Settlement officer, page 17. This is the letter dated 12th of June 2024. Subject confirmation of ownership of land passes with reference to the subject mentioned above as requested by the Deputy Commissioner Aizawl, owner of house pass number 335 of 2015, 336 of 2015 and 338 of 2015. So it's even in the table it's 338. They've made a mistake in the affidavit.
That will be a typographical error, yes, your lordship.
It's 338, Your Lordship. Not 337, 338.
Okay. Anything else? No.
So, Your Lordship, as per the judgment of the Honorable Supreme Court, it can be treated as deemed acquisition.
No, but then how the award will be?
Your Lordship,
because there was a reference proceeding in the case which you have cited.
in this case, but I mean, I understand, but in the earlier case also, award was passed as per the judgment of the Honorable High Court. If I,
No, in that case, award was passed because there was a reference proceeding.
yes.
How we will, assuming that your prayer is allowed.
Yes. My humble submission, Your Lordship, that assuming my prayer is allowed, that it should be treated as a deemed acquisition, and the railways should be, the competent authority, Kala, should be directed to make a necessary award in terms of the draft award 3 of 2019, by which the adjoining lands were acquired. The adjoining, the land for this project was acquired by the competent authority by draft award 3 of 2019. So, in that same process, my land has been also utilized. So, my humble submission is that it can be treated as a deemed acquisition, and the competent authority can be directed to pass an award.
No, in this apex court's order, perhaps the necessity of treating the acquisition as deemed acquisition because of the lapse of time.
Yes.
Here that manual,
Here, there's no much delay.
okay, heard.
If your Lordship will see, para 4 of the judgment dated 2020, volume 2 SCC.
Any hearing matter is there? Para?
Page 571, I'll read para 2, 3 and 4.
Yes.
The respondent state took over the land of the appellant in 1967-68 for construction of major district road being the Nadaun Sujanpur Road, a major district road without taking recourse to acquisition proceedings or following due process of law. The construction of the road was completed by 1975. The appellant, being an illiterate widow coming from a rural background, was wholly unaware of her rights and entitlement in law and did not file any proceeding for compensation of land compulsorily taken over by the state. In 2004, some similarly situated persons whose lands had also been taken over the respondent state for the same public purpose filed CWP number 1192 of 2004 titled Anak Singh versus State of HP, claiming compensation before the High Court of Himachal Pradesh. The High Court wide order dated 23/4/2007 allowed CWP number 1192 of 2004 and directed respondent to acquire the lands of the writ petitioners under the Land Acquisition Act 1894. Pursuant to the order of the High Court in 2008, respondent state initiated acquisition proceedings under the LA Act 1890 for only with respect to the lands of the writ petitioners and not the other landowners whose lands had also been taken over. So in our case also, since the adjoining lands have already been acquired by Railways Act 1989, White Draft Award 3 of 2019, it can be deemed, it can be proceeded as deemed acquisition.
It is acquired under which provision of the Railways Act? Section?
20F. It starts on 20A, Your Lordship. The preliminary notification comes under 20A.
Okay, I will deliver the judgment today in the chamber. I'll dictate it in the chamber.
I'm open.
To the chamber. Just in doing this.
Hearing list, item 9.
If I may seek your Lordship's indulgence, my Lord, if the matter can be listed after a week, my Lord. I have some personal difficulties today.
It's okay.
Okay.
He has a dental problem, I think.
Okay. Heard Mr. A.R. Malhotra, learned counsel for the petitioners. Also heard Mr. Samuel, write his full name, 7. Valal Shriyata Changte, learned additional Advocate General appearing for the state respondent, who prays for an adjournment on the ground of personal difficulty. Learned counsel for the petitioner does not oppose the prayer, hence same is allowed. Let this matter be listed
After 2 weeks.
after 2 weeks.
Obliged, my lord.
Item 10.
My lord, the counsel for respondent number 2 is not here.
Who is the counsel?
Mr. Pautu, I'll just make a call. He's around here.
I next the award asked by the collector to be lifted. The earlier award.
Okay.
It's part of the deal.
Your Lordship, my learned friend is coming.
Yes?
My learned friend, Mr. Pautu, is on his way.
Where is he?
He's somewhere in the premises.
Okay. Let him come. Or we'll because today I have to dictate one judgment.
Okay, post it on Monday?
Not Monday.
Tuesday, my lord.
Tuesday I have a fixed matter fixed in court number 1.
Monday is okay then, ma'am.
This is a small matter, it will not require more than half an hour. Lordship.
No, let me first dictate that judgment. Otherwise, things will pile up.
Yes. With your Lordship permission, if it is not causing inconvenience with my learned friend in your Lordship, the matter may be posted on Monday.
Monday? Tuesday?
Tuesday, I'm a little bit swamped up in court number 1. I have a fixed matter. It's a civil matter. I think that it will take some time.
Okay, let us. How many matters are on?
Tuesday.
Monday?
Monday.
What is the issue?
This is
POCSO.
POCSO Act, charge under Section 4.
And what is your stand? Appellant's ground?
My main I have 2 grounds, my lord. My main grounds is that the accused, the present appellant, is wrongly charged. He is charged to the offense he did not commit, penetrative sexual assault. From the prosecution evidence and from the
Evidence is not there.
Yes, ingredients is not there, my lord.
That is your stand.
Yes.
And other stand?
Other stand is that the learned trial draw section 29 and 30 presumption.
How many witnesses are there?
There are 10 witnesses.
Yes. 11 witness cited, 10 examined.
No
When?
defense witness.
On Wednesday.
Okay.
Or DB?
Thursday, there's only one hearing matter fixed. But I believe the Lordship has some reservations on Thursday.
Okay, let us hear it.
May it please your lordship. This is an appeal against judgment and order dated 25 1 of 2020.
Or just a minute. I am again reconsidering.
Okay.
We'll hear it at 2. We'll take up the matter at 2.
Please, we can take up this matter after TB next week, after BPF and get some page for.
Okay, on Wednesday.
Yes.
Wednesday. The heard Miss B. Lalrem Nemi Learned amicus curiae appearing for the appellant. Also heard Miss Mary L. Cante Learned additional public prosecutor appearing for the state respondent. Also heard Mr. Pautu Learned amicus curiae appearing for this. None appears for the either of the parties on call. Let this matter be listed after a week on a date to be fixed by registry.
Item 15.
Who is for the appellant? None appears for the appellant on call. Miss Mary L. Cante, Learned additional public prosecutor, is present. Let this matter be listed again after 2 weeks on a date to be fixed by registrar.